Okay, folks, we're watching the Tex McIver case out of Atlanta, Georgia. We had some issues there with the feed breaking up, but it looked like they were sort of getting to a point where they were considering taking a break. That's what it looked like they were getting close to. So we're going to keep an eye on things as we stay on the air here. One of our guests here on the Law and Crime Network is Andrew Maloney. He's along with me now. He's an attorney here in New York City, and he's so accomplished that I'm almost afraid to ask him a question because he might prove me wrong.
I usually don't do that, Aaron. Thanks for having me. Enjoy being here.
So we're getting ready for a big point in this trial after a lot of testimony that was a little bit dry about gunshot residue, and it went on and on and on. But we're getting close to the point where the interview with the defendant is about to be played. And I say in part jokingly that we just spent 20 minutes talking about redacting 20 minutes from the interview. Why not play the whole thing at that point? But the bottom line is that they did cut it down. And this is a chance for the jurors to hear the defendant in his own words.
Yeah, it's a critical part of the trial because the defendant often doesn't take the witness stand. We don't know if Mr. McIver will take the stand when it's the defense's turn, but he is in effect taking the stand now because that video is going to be played in front of the jury, and they'll get to hear from the horse's mouth, so to speak, in terms of what his explanation is at a time period very close to the killing of his wife.
Yeah, it looks like they're going to take about a 5-minute break here. We do, I think, have the feed back, but they're going on a break. We thought that's the point that they were at, so we're going to bring you back to live testimony in about 5 minutes. In the meantime, I wanted to unwind some of what we saw this afternoon. We listened to this discussion about the gunshot residue and whether or not the technician knew to collect it in such a way that would allow attorneys try to estimate the distance between the barrel of the gun and the seat through which the bullet went. Because remember, this defendant was sitting in the back seat, his wife was in the front passenger seat, and a friend was driving. And the allegation is that he shot her through the seat, through the back, and ultimately killed her for financial reasons. So it seems to me that what the defense was probably trying to get at is, look, the state isn't able to tell us how far away the gun was from the seat, and that might be a gap in the state's theory. Because, for instance, if the gun was right up against the back seat, it would smash to smithereens this theory that it was accidental. But we just don't know.
So the question really for the jurors will be how much of that testimony actually really matters in this case. There's no question that Mr. McIver had a gun, that it was loaded, that it went off, and that it shot his wife through the seat.
And it was in this grocery bag. We saw the pictures of the bag in the car. So, like, how much of the residue would have escaped from the bag to a meaningful point anyway?
Hard to say. With the bag, you would have had a flash. A lot of it would have been contained inside that bag, but some of it undoubtedly would have escaped the bag and gone in different places. In any case that a prosecutor brings, any case that detectives investigate, there's always going to be some holes here and there. No investigation is perfect. Life is not perfect. And there are just some of those things that are mistakes that are made along the way, or things that are really not mistakes at all. They're irrelevant, and yet the defense lawyer will try to exploit them and have the jury believe that these are very important gaps in the evidence or things that are really important to the case, and try to raise the specter of reasonable doubt. Sometimes it's effective, and other times it's really an irrelevant waste of time.
In this case, it seems like the prosecution is putting everything into evidence, when really this all boils down to intent. And that's a little bit tough for a jury to guess.
Yeah, I have to agree with you on this one. The prosecutor has to lay the foundation to get certain pieces of evidence in. Sometimes it's tedious. They have to cross their T's and dot their I's, lay the foundation, and get that evidence in before the jury. Now, if you have a defense lawyer who's objecting to everything, you're going to have to take your time and do that. If you have a defense lawyer who's not objecting to a lot of things, which is kind of what I've been seeing so far, then you should be able to do that relatively quickly. And if you don't do that quickly, you have the concern that you're boring the jury and putting them to sleep. And not only on a daily basis, but in terms of the length of a trial, the jury gets tired. They lose focus on what's important, what matters. And by the end of it, weeks later, they forget a lot of things. So the length of the trial is the enemy of the prosecutor. They need to get to the point and get to it quickly.
Yeah, let's listen to some of the cross-examination of that crime scene technician who collected the gunshot residue. We'll be back after this.
Do you recall what it was? that you were first called to process this vehicle?
I received the call at 10:30 a.m.
On what date?
September 27th.
September 27th. And you processed this at APD?
At the crime scene annex.
Right. So you understand the vehicle had been moved to the crime scene annex, correct?
Yes.
Do you know how it was moved to there?
I don't know specifically.
Do you know who moved it there?
I imagine one of the tow companies, but I don't know specifically.
Okay, right. Just tell me you don't know. Do you know when it was moved?
I do not know.
Do you know whether or not anybody? Well, do you know when the vehicle? You don't know where it was moved from. Sorry, correct?
Correct.
Were you given any information about who had been in and or out of the vehicle prior to the time that you processed it?
The only information I would have been given would have been the victim information or possibly the suspect information.
But nothing else?
No.
All right, so you didn't know if the vehicle had been driven after the event in question?
No.
You don't know how long it had been driven after the event in question?
No.
You don't know how many people had been in and out of the vehicle after the event in question?
No.
You don't know whether it had been driven by, for example, a valet at Emory Hospital?
No.
Okay. You don't know whether a valet had gone back into the vehicle to retrieve anything from the vehicle prior to the time that you processed it?
No. I don't know anything about the vehicle prior to what happened.
Okay. Are you familiar with something called Locard's principle?
No.
The principle of transference?
Yes.
Okay. Transference being any time two surfaces come into contact with each other, they leave something on the surface.
Correct.
Correct? Okay. So that we know that if people come in and out of a particular crime scene, for example, there is always something that is left behind.
Okay.
Would you agree?
Generally, yes.
You're the crime scene guy,
Yes.
right? Okay. So that one of the things that is done, and we've heard a little bit about this, is an effort to preserve the scene, correct? To preserve any crime scene.
Yes.
Because you don't want people going in and out of it, correct?
Correct.
Because it may change the scene for one, correct?
Yes.
It may disturb the parts of the scene, correct?
Yes.
And there may be elements that are left there that were not there when the event occurred, correct?
That's correct.
Okay. But let's start from the principle that you don't know about any of that prior to the time that on the 27th at some time you were called upon to process the scene, correct?
Correct.
All right. And the scene in this case was a vehicle, right?
Correct.
We were reviewing testimony from a crime scene technician there as we wait for court to go back into live session in the Tex McIver case out of Atlanta, Georgia. I want to show you what's going on in the courtroom as the jury is on break. We can already see the video queued up in the courtroom monitors that we're waiting to see with bated breath here on the Law and Crime Network. That's the video of the interrogation of the defendant. This is one of the chances that the jury will get to hear the defendant in his own words. This was back at the police station as police were investigating the case. That we expect to come up as soon as the jury's back from the break. But as we continue to talk, Andrew, about this gunshot residue testimony, we want to talk about what's coming up next, because this afternoon a lot of us were sitting here listening to this testimony saying, hey, look, gunshot residue, is it a big point, as you pointed out? Maybe not, but this prosecutor has been great about timing. And we were just talking amongst ourselves. The prosecutor always wants to end with something really strong at the end of the day, and it looks like that's exactly how they have timed today out to play along.
Yeah, that's exactly what you want to do as a prosecutor or a defense lawyer. If you have the stage, you want to end the day finishing with your strongest or highest point for the day and sit down and not give the other side an opportunity to rebut it or have some redirect or recross. You want the jury leaving the courtroom that evening thinking about what just happened and thinking about that overnight. That's pretty powerful when you have sort of the last word in a particular day and in a particular critical part of the trial, like the words coming from the defendant's own mouth on the video.
Of course, it would be great to play that on a Friday so that the jury has all weekend to sort of play it over in the jury's head. Of course, they can't talk about it with anyone, but they at least would remember it. Let's talk a little bit about motive here, because ultimately this case boils down to intent. Did the defendant intend to kill his wife, or was it an accident? And there's a lot of evidence that both sides can work with here. You have the statement from the victim herself saying it was an accident. That's going to carry some weight, but there are also some statements in evidence that she was going to change her will, that is the victim. And we have the victim's friend, Danny Joe, who was driving the car that night, who said on the witness stand a few days ago that about a week or two after the shooting, the defendant, Tex McIver, admitted to her that he himself had canceled several of the victim's appointments to change her will. Now, that piece really stuck out at me. And some people are saying, well, she could have gone and changed it without his permission. Maybe it did require his permission. It depends on the individual state's wills statutes and how wills are interpreted in that individual state. In some states, you can't write your spouse out of a will at all. If you try to, it's just invalid. In some states, you can. In Georgia, you can. In some of the states where you can do it, you have to give the spouse notice that it's happening. That's one piece of this that I don't know, but I know in Georgia you can write a spouse out of a will. The jury's really got to have to get into this and say, hey, look, do we believe that this guy would be in financial straits if she, for instance, didn't bequeath the ranch that she owned to him? And that's what this case is all about. Trajectory stuff, probably a minor point.
Yeah, I mean, those facts, that testimony does not bode well for Mr. McIver. Is it enough? It's a question. I mean, there certainly is room for a doubt, potentially, depending on how the rest of the trial plays out, and also whether or not Mr. McIver himself testifies. Those two facts put together might be enough to show motive. I'd like to know a little bit more, and I wasn't present for this part of the trial, about how the defense claims that gun went off accidentally. Guns don't typically shoot by themselves. So I understand it was a revolver. Perhaps the hammer was cocked. I don't know.
That's one of the big questions people are getting into is, you know, if it was cocked, it would only take about 2 pounds of pressure to set it off. And it was wrapped up in what appears from the photos to be a grocery bag. And a few people have insinuated that that bag was wrapped up around that gun, and if it's sitting in his lap at an odd angle, maybe part of the bag snagged the trigger as he was either manipulating it or moving it around, and maybe that's how this thing could have been an accident. It's a lot of could have, would have, maybe. It's a lot of speculation, but it's at least arguable.
It's arguable, and it's not impossible. It's maybe not likely, but it's not impossible. I'd like to know a little bit more about why he had a gun in the backseat of the car to begin with. He's got a loaded gun in a paper bag. That, to me, is the first place I would start. And I don't know, I haven't seen the videotape of his interview, but that's one of the first questions I'd be asking is, what were you doing with the loaded gun in the backseat of the car? Why was it in a paper bag? Those things seem, at first blush to me, to be a little bit suspicious. Has he ever explained, to your knowledge, why he was carrying a gun in the car?
Well, I mean, we know that he took it out because he was fearful that there were some people in the street in this so-called bad area of town. That's why he apparently took it out. Why he kept it in the car, I'm not sure that I've heard a specific explanation for that. There may have been one out there that I just haven't seen yet. But look, in some states, gun ownership is more common. In Georgia, presumably, it's more common than it is in the New York City area here, and that may be part of what was going on.
Well, I'd like to know how often he traveled with his gun. I mean, if it was rare that he traveled with his gun, that would raise some big questions in my mind. If he is the type of person that regularly travels with his gun, and other witnesses can corroborate that, then it might be more defensible on his part. If he is a person that regularly travels with his gun, which is not against the law, provided he's got a permit to carry. And this was just one of those days where he had the gun as well. But that's the place I'd want to start as a detective, why the guy had a gun in the first place loaded in the backseat of the car. I understand he was drinking in the car ride. There's a lot of issues to sort out.
A lot went on behind the scenes. We're going back to court now. Again, we're expecting to hear the interrogation video of the defendant.